Welcome to Council Culture, the Business of Law podcast brought to you by Byfield. Welcome back to Council Culture, the Business of Law podcast. Michael is back on this week. Hello, Michael.
Hey, Meg.
Quite a lot has happened this week. Let's dig in. Let's start with the DeepSeek kind of chaos from this week. So obviously everyone will have seen in the news. I think that's been the main kind of business story of the whole week, that this AI challenger, Chinese challenger, DeepSeek, has kind of broken the internet and broken the stock market in the US as well. So let's dig into that. Apparently the software is kind of, well, better than what the companies in the US have been putting out, which they weren't expecting that to happen so suddenly. And that's taken the whole, NASDAQ was down, I think it was 3.5% on Monday. S&P Global it was down by 1.5%. Nvidia stocks dropped by 17% as well last night. So yeah, it's not been great news. I think they were reporting last night that it was a wipeout of $1.2 trillion in the US for all the kind of tech companies. So it's almost like a volcano that just erupted out of nowhere. So, Michael, what are your thoughts so far?
Well, obviously, we'll come on to the legal sector lens in a minute, but hey, I think it's great. I think it's brilliant. Who doesn't want cheaper, less energy intensive, better AI? I mean, I read a comment on VFT, which I very much liked, which said US companies spent billions to go from point A to point B. A Chinese company spent millions to go from point B to point C and then open source the results, making the cost of going from A to B a no return investment. Everybody will build on the results of that cost, but no investor is going to get paid for that. So I think that sort of summarizes things really nicely. No, people didn't see it coming, but technology by definition is constantly innovating, improving. It's also a kind of almost an, let's face it, we've had America first policies under Biden as well as Trump.
Yeah.
And the export controls on the chips have had the unintended consequences of driving innovation. And I think protectionism in every form creates unintended consequences.
Yeah.
And this is an example of that. And if, the stock market, in terms of the tech stocks, some of the tech stocks went down. There's big questions about OpenAI, et cetera, et cetera. However, the companies that are heavy users or expected to be heavy users of AI saw their stock prices rise because the cost of them using AI is expected to be much cheaper than it was thought to be. So there was no overall market rout. It was a very tech-specific development. I think when you turn to, there was an article in The Lawyer talking about what it means in the legal services space. Obviously, legal services are great in terms of aspects of AI because generative AI works really well the more information you give it. So it's issues and topics where there is little information that it hallucinates. The more information it is given about a topic, the more likely you are to get sensible results, which is why, Harvey and others are, pretty good by all accounts and will only improve. Will we see a competitor, Harvey, arising from the open sourcing of the DeepSeek model? I don't know. It would be very interesting to see if it does. But I think certainly for all sectors, including the legal sector, cheaper AI applications is definitely potentially good news. And it'll be interesting to see where it goes next. One to watch, I think, for now.
Yeah.
I'll certainly be downloading DeepSeek and having a play around with it, as millions of other people have done. And but this is I think the article in the Lawyer ends with talking about this is the start of democratizing AI and showing what's really possible. And democratizing AI is great. I mean, I don't want to be in servitude to AI models run by a couple of tech bros in America.
Yeah.
Do you?
Well, especially not at the moment, given like it's funny because yesterday I was seeing comments about but it's a Chinese company. There's spyware inside and stuff, which is like okay, but then again.
Well, where do you think AI models have been scraping data from all sorts of places?
Exactly.
It's kind of funny to see a sort of like, oh my God, there are IP issues. It's like, well, there are massive IP issues in AI generally, which have barely started to come through the courts yet. So it's kind of like, it's kind of hilarious that there's a certain amount of, oh my God, they might have compromised our intellectual property.
Well, and also it's just like, I'm sorry, but the US companies have been doing the same for a very long time. Some of them, whether that's sabotaging their own kind of hardware to get consumers to buy more of it, or whether it's like, placing you under, well, not surveillance, but you know what I mean, like just checking your activity and things like that. Like, I mean, like this is not new. The tech industry overall has got an issue with this, has grappled with this for a long time. And this will be no different. And, I think there is an argument around, do we want maybe another government to have information and stuff? Well, look at what's happening in the US, where basically the government is currently heavily influenced by big tech CEOs. So it's not any different to me. So it's interesting. I mean, as long as it's kind of, for AI, I think my biggest concern with it is its climate challenges. And as long as you kind of develop products that match those ESG concerns, I think that can only be positive. And I'm sure there'll be a bunch of challenges, with this type of tech, especially because it's not really regulated yet. So when the regulations do come through worldwide, I think it's going to have major repercussions on everyone using these things. But like,
it's an interesting point. It's an interesting point you make about the focus on ESG, because historically law firm emissions are pretty tiny compared to other industries, given you're talking about some offices, some people getting on planes, historically a bit of printing, but very little even that. So the switch to more AI-driven stuff is going to have a much bigger impact in terms of their emissions because of the energy intensity of AI. And if this innovation, if a DeepSeek model is actually much less energy intensive, then fine. But this is still a good news story for AI in certain respects, and the proliferation of different models. And it should facilitate innovation. And like I said, if it's cheaper and less energy intensive, then everybody wins in the long run, except people who maybe invested billions in the initial models, which are now kind of like
where's my money? Where's my cash?
And just a note that it was Data Privacy Day this week, so we should all be very mindful of such things.
Yeah, and in a way, it might keep litigation teams really busy as well, because I'm sure a lot of these kind of investors looking for their cash now might try to find ways of getting that back, and there will be millions of ways to do that. One of which, if you're like a shareholder, might be actually a dispute. So it's super interesting. Let's see how this story develops, because I'm sure it's going to be a very long running one. But yeah, I think as long as you get technology that's actually kind of getting better, I don't think it's a huge problem, and the others will just have to follow through with it too.
Yeah, I think a lot of people have spoken about, moving on to the next story, a lot of people have talked about the impact of deployment of AI by law firms on reducing the need for the billable hour. And I think we're going to talk about that next, aren't we?
Correct. So I don't know if everyone's seen, but Suze Ehring at the FT did a fairly big read about kind of why the billable is still the king in the legal world. That was a couple of days ago. Very interesting piece, and I think the key element here is that now, the billable hours is not going to go away anytime soon. However, it seems that clients and people in the industry are questioning how that's going to work if you implement AI at the same time, which is meant to reduce the amount of time that you spend on tasks that you don't really need a lawyer to be spending so many hours on. So it's fascinating. This obsession with wanting to change the billable is also equally fascinating. We were discussing this right before. It works for law firms for many reasons. What would you want to change a structure that works, right?
Well, I guess it's client demand, isn't it? But it's an incredibly powerful tool. People have been talking about. I mean, I started my career in the early 2000s in terms of working in and around the legal sector initially as a journalist, and I literally for as long as I've been working, people have been talking about the death of a billable hour. The reality is that it is an incredibly effective tool for managing your revenues, managing your and also for managing your costs. Where do you think the pay rises that get deployed consistently come from? They come from hikes in rates. Of course, the pricing power of firms varies, but it doesn't take very much. You only need to put a little bit on your hourly rates to generate a lot of extra profitability, and associates know that. And the pay wars are largely because associates know that, but also because the firms at the top have sort of weaponized their pricing power to be able to charge more to retain, incentivize, and attract the best people to keep them. And that has driven a lot of the pay wars, but without the billable hour, all of those pay wars, a huge amount of this tension would sort of deflate out of the market. It fundamentally is driven by clients. Law firms are not going to voluntarily get rid of it because it is brutally simple yet effective, and it allows you to manage productivity. It allows you to understand productivity. It allows you to understand the value created relative to the time spent on work. And I think that the piece concludes with a good comment saying, even if firms shift to a different fee model for clients, the billable hour will probably survive internally, as it's the simplest way of measuring output.
Yeah.
It's likely that this will be combined with other data to provide information on the value created relative to time spent. Over time, it does seem the internal use of the billable hour may be of more relative importance. And I think that's right. As more fixed fees come into play, as AI tools are more deployed, there will always be a certain amount of core billable work.
Yeah.
But some of it will move more to fixed fees, et cetera, but it will still be incredibly important to record those hours to be able to understand, as the article says, the value created relative to the time spent. And we in our own business record hours, record time. Some of what we do is billable work, and some of it is retainer work. But we always track our hours to try and understand, what the financial value of the work that we're doing.
Yeah.
And as an internal metric, that is incredibly important, and it allows you to make good decisions. And so you can see why firms are massively incentivized to keep it both externally and internally for as long as they can. So I don't think it's going to go away anytime soon.
No, and also I think if you had to change the billable hour, you'd have to change the whole system of originations and whatnot. And I think that's in itself just such a nightmare to implement for most firms, especially on a large scale. But it's interesting because, how do you measure the cost of AI? It's really interesting because, it might do all of this kind of drafting of certain documents or reviewing things and stuff, but you still need a pair of eyes to actually double check what the AI has done. So it reduces the amount of time, but actually you still have human effort going into that too. And secondly, you have to keep the software updated at all times. You can't just, use ChatGPT version 1.0 for 5 years and, bill your clients the same amount the whole time because you've got the shiny new toy at the beginning and you might be the only firm with that. Great, you can charge anything for that. But then 5 years down the line, that's no longer the shiny new toy and you can't really justify that. So I just think it's really interesting how that element of bringing AI into the day-to-day work of these law firms, I think, makes pricing quite a different thing. It won't change the billable in itself, I don't think, that much, because whatever time is actually not spent doing this type of work, they'll just spend doing something else for another client or whatever. So the lawyers will still be billing the same amount of time, but just for across various projects, more projects potentially. So it's really interesting. I think I don't think it's going to go away. I wonder if there could be, we've seen recently, and I think that's going to go into the next story as well. We've seen recently kind of rewarding the top performers at firms differently, whether that's through a special bonus pool or all sorts of kind of arrangements. And there's a great piece in law.com from Andrew Maloney in the US about this, about kind of the law firm struggling with partner-based segmentation, and keeping the rainmakers happy and paid really high while keeping everyone else happy at the same time. And it is a struggle. I wonder if the answer to that actually would be, for those top rainmakers, not getting them to bill more, but actually to have very specific rates for them. Because if you're saying that it's your top biller, and it's probably someone, if they're the top biller, then you would assume that it's someone who's actually outstanding at what they do, then presumably the quality of service and of the work might be slightly, potentially better than the rest of their colleagues or whatever. And I wonder if actually, a lot of companies will pay extra just to get the top dog, so I wonder if that could be an answer to that. I don't know.
I think fundamentally it's about who owns the books of business, who is originating work. And I think, again, we've just talked about the billable hour, but origination of work and ownership of books of business is obviously also being incredibly important. In terms of talking about billable hour and origination, we're talking about the two big issues that link into profitability and partner compensation. Firms have different ways of measuring this, but if somebody is, and it is cultural. If you have a culture of collegiality where everybody is supposed to share, and you still got only a relatively limited modifications to a lockstep system, and your system is based around that collegiality. If somebody brings in loads where everybody benefits, even if there is a component of additional compensation, some firms are like that, but increasingly the top firms are not, and have ways to reward their superstar partners who originate books of business worth tens, 50, 100, hundreds of millions, with a lot more money. And that's only right because of the competitive tensions between firms and the fact the legal market is still so fragmented. Finding the right balance is really difficult, but I think, there's an interesting comment where one of the people quoted in the article says, when you pitch to a client, it may just be you as the main partner, but clients value a firm that has cross practices and can handle other issues and problems. From my perspective, the successful firms that have been able to handle this have been the ones that show that, yes, one group may be more successful, so to speak, but it's also successful because of the support from the other practice groups.
Absolutely.
And I think if you get too deep into individualistic star culture and everything else is subservient, star culture and money are very bad glue for holding firms together. You need to have more than money, and you need to have more than a handful of stars, and everybody else is kind of like not relevant. Because you need to have everybody feeling like they are part of high performing teams, and you do need to have that element of collegiality. But how you move partners up and down, how far can you move somebody up in a single year? How far can somebody fall in a bad year? Is going to be an ongoing iterative debate. If a firm takes it too far, then again you get too much star power. And if a firm doesn't go far enough, it starts to lose talent to others. So, it's a really important question, but I don't know what the answer is exactly, other than that if you take it too far, you're going to have major problems.
And I think it's all about the way you communicate it as well internally. And I think that's the most difficult part, I guess, because if you're a top performer one year and next year you're not, then it's really hard to handle those conversations. But I think it's easier if you're in a black box system, for example, where obviously the conversation doesn't really exist as much, and it's just finding. I think the firms, the financial struggle in itself is one thing, but then the way you communicate it to people and the way you kind of keep morale up is equally as important, I think, and is that is a cultural and communications issue. And I think equally, it's not even just at partner level, but even at lower levels, in the FT story, they were talking about well-being of the associates and stuff, which has been ongoing for so long, right? But I think the way firms handle that internally, and it's not just the initiatives that they've got in place and the support they've got in place, but also just, the way people talk to each other and the way people collaborate. And I think it's easier to do 12 hours a day 6 days a week if you're in a team that's actually really supportive than if everyone just
if it's all about if they're different drivers. I think it's kind of funny that you've got two former legal journalists sat here 2 weeks in a row advocating for black box compensation systems, right?
It's going to make your life so much easier internally.
But maximum visibility and transparency internally is one way of doing it. Black box another, etc. But you've got a couple. You have the value of the equity points and you have the number of equity points available. And obviously those are the two things that firms can ratchet up and down. Yeah. Obviously if somebody who has a great year you might give them more of one and less of another to sort of equalize things a little bit. So you've got a couple of different levers that you can pull on to make sure things don't get completely out of control.
Yeah.
But it is inevitable, as the article says, that some people are going to be unhappy in any given year because they're going to feel it's unfair, or they haven't been paid as much as they should have been, and their contribution isn't being valued. And firms do need a balanced scorecard to a reasonable extent, because if you have somebody who brings in tons of work, is a very good lawyer, but is a horrible person to work with, burns through associates the whole time, creates sort of cultural chaos, then that, and you don't take any of that into account, then again, if you are the kind of firm that doesn't care about any of that stuff and it's all about the dollars, then fine. But if you have a good culture and you tolerate that sort of behavior and don't penalize it in some shape or form, then that's not really helpful. Equally, if you've got the nicest person in the world who's a good lawyer, but you would never put them in front of a client and they're useless at business development, they're not gonna get paid as much, and they shouldn't get paid as much, because you do need to have a balanced scorecard, and that it's finding that balance between collegiality, culture, technical skills, and the book of business, the size of the book of business, and the amount of billable hours. So, the best leadership teams, I think, probably don't have completely rigid systems and do flex as they need to, more or less all the time.
And I think the best leadership teams as well, kind of, first of all, they understand their business, and they are usually people like persons. Do you know what I mean? It's kind of like it's I think it's, if you're all about the dollar and stuff, I think there's only, like, this is the sort of stuff where it's bad not only for your own culture, but also it's going to be played out publicly at some point, and that this is not what you want. So it's really interesting, these conversations. And it's fascinating to me that the press is still so hot on this stuff. I mean, I guess because the figures are so high, it makes sense.
Well, you're going to get, there's a lot of money at stake.
Yeah.
And in any industry where you have got people getting paid tens of millions of dollars every year, it's of interest. It's interesting. People are interested in people making loads of money. Whether I wouldn't say you're a bit more interested if you're a sports star or a celebrity, admittedly. Lawyers are, let's face it, a little bit less interesting, and that's only right and fair. I don't think as a partner in a law firm, do you really want to be famous.
No, I don't think so. I mean, some of them do, to be fair. In the US, I think, but some of them definitely do.
The kind of ones where you see the adverts on like billboards for personal injury stuff and crazy. Florida's like full of these the kind of attorney advertising stuff is crazy.
Yeah.
But people can make a lot of money, and I don't think the interest in law firm compensation systems in the legal press is going to go away.
No.
I think the interest in the wider business press and wider world is somewhat limited.
Yeah. Moving on to a bit of a kind of court case situation. So Susie, again in the FT, published a story yesterday about the law firm that was representing Wagner founder Prigozhin in the libel case. Basically, the SRAs decided that they were not going to pursue anything against the firm, stating that there was a case to respond according to the High Court, and so therefore this was not really a slap. So this comes just I think maybe a couple of weeks after an Osborne a partner was fined £50,000 by the SDT for misconduct. And this is really important because actually the SDT said that there was a lot of talk that this would be the first, this Osborne Clark case would be the first slap case. But turns out the tribunal was adamant about this, that it is not. It was not a slap case, but the partner was nonetheless fined £50,000
for misconduct.
For misconduct. So it's interesting. Obviously, the SRA has been really keen since 2022 to crack down on slaps. There's, I think, around 40-something investigations at the moment going on by the SRA into these types of allegations. We're yet to see any major action from this. And I guess these two cases, what's for sure is that it's not set a precedent for anything. And if anything, for me at least, it's confusing things a bit more as to what actually, when is the regulator actually, like, what constitutes a slap, and when is it a problem that the regulator needs to get involved with? And I think it's a difficult question that the regulator itself is trying to grapple with. Clearly, the SDT is too. And I think for a lot of firms doing defamation work, it's these types of cases have not really been helpful in kind of figuring out the next steps.
I mean, from obviously we do some reputation management work in terms of our business, and at the same time, I'm not going to claim to be an expert on where the legal line is in terms of what constitutes a slap or not, but it doesn't seem like that line is clear.
Yeah, it's not been drawn yet.
It doesn't. On the one hand, you have this case where you've got some people saying it should have been the Russian warlord one, where people are saying, some people say it was open and shut, but the SRA were pretty clear in saying no, the firm did what it needed to do in terms, and there was no case to answer. The Osborne Clark case with Dan Needle, obviously, on the face of it, looked like it involved much less serious things, and it was said it wasn't a slap, but there was misconduct. So I'm confused. All I would say is, fundamentally, the pendulum has swung a bit away from the era where writing nasty letters was enough. And if you have got a major reputation management issue, you need to have PR people in the room as well as lawyers right from the start. And that is just a fact if you're going to manage a reputational crisis effectively, because you need to have a PR strategy, not just a legal strategy. So that is all I would take from this, other than that it's all a bit confusing.
For sure. And lastly, a story by John Hyde at the Law Society Gazette. who from yesterday, stating that the SRA is ready to begin prosecutions arising from the post office scandal when the public inquiry report will be published, and that is set to start around this summer. So this is, I guess, a long time coming, because the inquiry was for how many years? Like 2, 3? I'm not entirely sure anymore. It just finished, so the report should be published in the next few months. John says in his story that more than 20 firms and solicitors are being investigated by the SRA in relation to their involvement in one of the biggest miscarriages of justice in British history. Well, this is, I guess, obviously, if you're one of those firms or individuals, you absolutely need to prepare for whatever may come next, because it's at investigation stage right now, but there is a chance that it might go further afterwards. And I would suspect that, given the publicity around the inquiry and the kind of allegations made during the inquiry, I would suspect that actually you would need a bit of PR help at one point. I don't know when. I don't have a crystal ball, but it's very possible that you might need some at some point.
Well, look, I think it's the case that you have to take your regulator extremely seriously.
Yeah.
And this is going to be a process that plays out in public. Whereas the inquiry, yes, it was looking at what had gone wrong, what the learnings are, et cetera, but it was about the post office. Aspects of it were certainly about the role of lawyers. However, this process is going to be exclusively about the role of lawyers and whether they complied with their regulatory obligations or not. Yeah. And so it is far more significant.
Yeah.
It may not be as significant in terms of whether, your neighbours are aware of what's going on, because there won't be.
Yeah.
But in terms of the impact on
the industry,
in terms of the impact on the reputation of individual lawyers and firms, and
their right to practice,
their right to practice,
yeah.
Significant fines, etc., going through all of this again, but where it is not about the wider context so much, but about the role the lawyers played, with both, by the looks of it, expectation that firms and individuals will be, some of them at least, maybe many of them, will be referred by the SRA to the SDT, is going to be difficult for those impacted to manage, and it needs to be given careful consideration, because fundamentally it might be over in the mainstream media, but this is not over as an issue, and the regulatory implications are significant, and firms just have to be mindful that it all plays out in public if they're referred to the SDT.
Yeah, and John is saying in his story that the SDT said last year that it was preparing to receive referrals from the SRA this year. So look, we don't know what's going to happen. It's still at investigation stage. Some of them might completely lead nowhere. But I would be surprised if there weren't a couple of, individuals or firms or, who might actually face at least some regulatory sanctions at best, or full on trial. And you need to be ready for any possible outcome, really.
Yeah, there's a lot of work that's going to need to go into prepping around this and the various news events that are triggered by an SDT referral, including the referral itself. And obviously there'll be case management hearings. It may be the case that some of these are bundled together. It may be the case that some of them play out separately. Obviously the legal press themselves will be interested throughout.
Yeah.
And the reality is that, actual regulatory sanctions on individuals and on firms, they matter when it comes to client choices, when they come to future business development, where it comes to the kinds of people that you can attract.
Yeah.
If you have got too many black marks against you, or for very serious things, there is a genuine impact which goes beyond just for PR. So controlling the messaging, making it clear. If there was wrongdoing, maybe there'll be an agreed outcome in some cases. In some cases, maybe firms will fight referrals. But those will play out all of that plays out in public.
Yeah.
And there will be greater scrutiny, greater media interest than ever before, I think, on SDT hearings through the post office, through the referrals that come via the fallout from a post office scandal.
Absolutely. So, we'll definitely be keeping an eye on that. And on that note, I think that's the end of the podcast today. Thank you, Michael.
Thank you very much, Meg.
And to everyone listening, we'll be back next week for another episode, and we're on Spotify and Apple Podcasts.
You've been listening to Counsel Culture, the Business of Law podcast brought to you by Byfield. Thanks for listening. Don't forget to subscribe and join us again next week. We'll be discussing some more of the biggest stories in the legal sector.